Yes. Hello, everyone. Whoever watching from UK and from outside the UK, very welcome from my live video in Facebook, YouTube, and different social media platform. Today, I'll give you some important update following the government announcement, which is the breaking immigration changes, which is coming from forcing from 1st of October 2020. This is particularly important for EU nationals, EU family members, or those who basically EU nationals want to come to the UK. So that what are the changes come from the 1st October 2021. In addition to that, I'll give also some update, which is basically a case law, I would say, the changes which is coming from the highest decision of the highest court, and this decision is particularly important as well, I said. So those who are in the UK for limited leave to remain, and you will see how the continuous residence or an in-time application could lead a break of continuous residence, and the effect is you might missed the opportunity to get the indefinite leave to remain after end of 10 years period. Let me start from EU law. So from the 1st of October, the EU nationals or any EU family member who want to come to the UK from Europe, they must use their passport to come to the UK. So that means that from 1st of October 2021, EU EEA such national identity card will no longer be accepted as a valid travel document, and passport will be required for entry to the UK. So that was very important. I said many people, especially for EU nationals or their family member, who maybe will come to the UK for visit, holiday, visit family, or for any other purpose. They hasn't made any passport yet. So if you are in the UK and if your family member, friends, family, or relative are in Europe, ask them to make a passport to for future travel to the UK, because until 1st of October, the EU nationals and their family member can come to the UK using their ID card. However, the government changed the rule following the Brexit that ID card is no more valid travel document to come to the UK. So this is what for EU national. But remember, this ID card requirement, ID card that is invalid for travel is not applicable for those EU citizen and their family member who are already in the UK, who are residents in the UK, who has settled or pre-settled status. They can still use their ID card to travel up to 2025. So that rule is only applicable for those who want to come to the UK, who are not residents in the UK. But in any case, I will advise all of you who are in the UK, even use your passport or apply for passport. Second, EU rules, what is changed is come also an important that an EU family member who are in the UK on visit visa, or if you are on visit visa but is a EU family member, they can apply for EU family permit, EU residence card. So that's the new changes. That is that from 6th of October 2021, the temporary concession to the effect of outside the Appendix EU, where the certain joining family member are concerned, as currently set out the EU settlement scheme, caseworker guidelines that from though a late another important also, which is also relevant in this regard, that through a late application can still be made for where there are a reasonably ground as the white person missed the deadline. As we know, the deadline has passed for EU settlement scheme, but still you can make application if you have a reasonable ground that why you cannot make the application on time. So these are the two changes. One is if anyone in visit visa, they can apply from inside the UK to join as a EU family member on the basis that the EU residence card under EU settlement scheme, so pre-settled status under EU settlement scheme, you can apply despite you are in the UK as a visitor visa. And as a deadline, what I said, this was previously guidelines that those who cannot make the application on time, I mean, until the 30 June 2021 for any reason. However, now you can submit a late application that is incorporated in the immigration rules. So the government's following the Brexit deadline, the government introduced the policy guidelines which allow the people who missed the deadline to make an application for pre-settled or settled status. Now that guidelines incorporated in the immigration rules appendix EU that the late application will be accepted under EU settlement scheme for settled or pre-settled status if you show a reasonable cause why you couldn't make the application on time. And there is some list of reasonable excuse, for example, medical reason for travel restriction, coronavirus related reasons, so pregnant woman who give birth outside the UK. So these types of reason you can select, and then you can submit a pre-settle application under EU settlement scheme. Now let me move on the immigration rules. So the case law came that, as you know, if anyone live in the UK continuously with lawful residence for 10 years, he or she can apply indefinite leave to remain. That is, when someone visa is expired, you must make an application in time under immigration rules paragraph 39E. Now, immigration rules allow that you can make the application in certain circumstances after 14 days of your visa expire or 28 days before your visa expire. Now the issue is, when your visa expire, although immigration rules allow you to make the application after 14 days, but are you an overstay at that point if you make a late application? There are lots of cases. The latest case was Wasim and others for Secretary of State. Before that, also Hawke case. There are a couple of cases, but these cases dealt with the different issue. That is whether overstay 14 days is a overstay, whether it's break the continuous residence or not. But in any way, the outcome of all these cases was that if any 14 days gap which previously made previous extension, that will cover, this is called closed gap, and what is the open-ended gap, which is last 14 days. So if someone make an application for extension by using after his visa expire, so for example, I give an example that will clear that someone make an application for on 10-year basis. When she or he completed 7 years, he make an application after his visa expire, means within 14 days, and then visa accepted, he got visa. That is called close-ended gap, 14 days. Home Court said that is not breach or break of his continuous residence. Then when he will apply for indefinite leave to remain on the basis of 10 years, that time he made an application after his visa expired, I mean outside within the 14 days. That is the last extension, because maybe to complete 10 years, he or she has a shortfall of 5 or 10 days. So what he did, as he think that he can make application after 14 days, so he wait 10 days and complete 10 years and then make an application. Now the question is whether he is overstay or not, whether it break his continuous residence, and the court said this is open-ended 14 days gap is what the court said, that is break of his continuous residence and he is an overstay. So if you want to claim on continuous 10-year residence, then 10 years means 10 years before you have to complete your visa expire. If you take the advantage of grace period, which is 14 days, you will be an overstay and you will not get indefinite leave to remain. So this was not the matter of today discussion, the case what I'll refer. What the court I'm referring is the case whether application is in time application or not, because paragraph 39E said that if you want to maintain your lawful residence or continuous 10 years residence, you must apply in application in time or on time. Now, the Court of Appeal in Secretary of State Home Department versus Mr. Ali 2021. This is the case last week. And what the court said that the court confirmed that an application is only in time if it is submitted before the date of expiry of the person's visa. Very important. The court said that application is only in time because paragraph 39 say in time application. If you want to keep your continuous residence, what is the in time application? Because immigration law allow 14 days late application. But the court said this in time means you must submit your application to the Home Office before expire of your visa. If you make an application after expire visa, I mean within the 14 days, within the grace period, this is not in-time application, and that will break your continuous lawful residence. So this is what the case law came from the Court of Appeal. And another thing also important, because I had no opportunity to give you this update about also a case law, I will refer that as we know the Immigration Act 1971, Section 3C, operate like a way so that you will not be overstayed. For example, if your visa is expired and you made an application before your visa expired or within 14 days, then when your visa expire and if your application is pending to the Home Office, in law, you are not overstayed. Your right, term, and condition on the residence will continue until Home Office make a decision. If the Home Office refuse and if you do an appeal, then until the determination of appeal, your leave to remain will continue. Your same term and condition will continue. Okay, although you don't have visa, but because your application is pending, that is what the effect of paragraph 3C of 1971, Section 3C 1971 Act. Now, the issue what the court deal in Akinola and Anwar versus Upper Tribunal and Anwar 2021 is a recent case 2 weeks before. What the court dealt with in this case, that is, if someone visa application for leave to remain refused by the Home Office, then someone supposed to make an appeal to the Immigration Appeal Tribunal within 14 days. But he didn't make the 14 days appeal within the 14 days. That means Section 3C leave will not help him. So what someone can do in this circumstance, whether if subsequently he made an application to the Immigration Tribunal after 14 days, and if the tribunal accept the application, will Section 3C leave will continue or will help him to keep his continuous residence? That is the issue. That was the issue before the court, and the court said that the Section 3C leave will revive from the dead again. That means if you fail to make the application or make the appeal within 14 days, that means your Section 3C leave will end. And then you made an application subsequently, which is late appeal, and Immigration Tribunal accept this appeal. At that point, your Section 3C leave will again start from dead. Okay, that means there is no gap, so your leave to remain will continue. I hope that will make sense. I'll give an example. For example, I applied for my extension. Home Office refused and give me 14 days to appeal to the Immigration Appeal Tribunal, but I cannot make the appeal within 14 days. For example, I didn't got a lawyer, or I had no money. I don't know. I hadn't received the letter. So after 3 months or 6 months later, I found the decision, and I decided, okay, I'll do an appeal to the Immigration Appeal Tribunal, although it is 6 months late. So when 14 days over, my Section 3C leave died. Okay, and after 6 months, I appealed to the Immigration Tribunal, and at that point, court accept my appeal. And that point, Court of Appeal said, yeah, that point, your leave to remain what is Section 3 sleep, revive, wake up again, and will give an operation retrospectively, that is from the last 3 months or 6 months before to now on, my leave to remain will continue. That was said in this case, Anor versus Upper Tribunal case, which is a recent case. So this is what all about today. I'll give you also an update for extended family member. EU extended family member. I gave last week, but I'll give you a brief information again for those who watching my video. Many people came in the UK as an extended family member. After they came, they left their family member, go somewhere, start working, and change their life. What the court said, that extended family member dependency, what you will prove before leave to enter, that must be continue while you are in the UK. So if you came as a dependent for health reason or any financial reason, you must maintain it. So those extended family member, if you think I got the resident permit, I don't need to maintain, that is a wrong idea, and you should maintain your family relationship and the dependency. So this is all about today. I hope this will help you, those who is relevant. Thank you very much whoever watching my video. Because I'm a bit busy now and I cannot regularly update in every day or every week, but I'll try to give one day update. If you feel this information is helpful, please feel free to share online. I will also give an update about Afghanistan, the resettlement scheme for the government, and those British nationals who are in the UK, or those who the people who are settled in the UK, Afghanistan nationals, what they can do with regard to their family members. Also, I'll give an update those who applicant or those asylum seeker whose application has been refused. Asylum application been refused by the Home Office, what application, whether you can make a fresh claim or that is the further submission, what you should do. This is very important. I'll give you the details in my next video. I'll speak about the detail of Afghanistan on my next video. Thank you very much, all of you. Take care.